So
I'm just,
can you send?
Why do I have to prove to her that I gave her a security deposit? She knows I gave it to her. I would have, through Community Housing Network, they would have never let me move in anywhere unless you better believe if I didn't give her a security deposit, she would have hauled me into court way before May.
Case number 25-03721-LT, Karen Jorgensen versus Michelle Mack. Appearance for the record. Ms. Jorgensen, state your name for the record.
Karen Platchen Jorgensen.
Ms. Mack, state your name for the record.
My name is Michelle Lyons.
Okay. They got it as your last name is.
Yeah, when Miss Jorgensen filed the case, she filed it under my artist name. I'm an author.
Okay. So we're here. You filed a motion, someone filed a motion, give me 1 second.
I did.
October 30th, I believe.
Yes.
This was the seeking escrow balance of $1,485, Ms. Lyon.
Yes, on the case itself, Your Honor, you gave me until October 22nd to turn in the keys, and Ms. Jorgensen until the 21st of October to put the $1,400.1485 in escrow at the courthouse to be returned to me, and she has not done so.
Okay, Ms. Jorgensen, the escrow, where is that? The 1485.
Well, in accordance to, and I wrote a letter to you, failure to provide forwarding address. I have not received a forwarding address from Miss Lyon.
I believe in this case,
And that's supposed to,
she doesn't need a forwarding address. She was ordered to put it in escrow at the 50th District Courthouse.
Yes, I think there was some issues going on with this case, and we were to put the money here in escrow, and I think you were to do an inspection. Let me pull up the notes in this case. So I said, defendant's motion dismissed granted, plaintiff failed to respond to defendant's motion dismissed, case dismissed for prejudice, plaintiff to escrow $1,450 250 District Court for defendant's security deposit by 10/21/2025. Plaintiff to take possession of property and review for any damages. Any proven damages may be recouped from security deposit after the $1,450, the $1,450 has been escrowed with the court. Now, that was my order. Now I'm just hoping people didn't say, well, we don't care what the judge said, we're gonna do what we want to do, because that's gonna be a problem.
Your Honor, in my case, I turned the keys in immediately.
So there should be $1,450 in this court. Jorgensen, you care to explain?
yes, I looked at the Michigan Tenant Landlord Relationship Act, and it says that the tenant is supposed to be giving me a notification within 4 days, which I never received from anyone. The keys were held for well over 21 days. I wasn't notified that the keys had been turned in. I got them the following day. The condition, Ms. Lyon also said that it was not cleaned, not taken care of, so I have a cost for that. There was furniture that was removed from my presence and from my property, and I have a photo of that with the letter that I dropped off this morning, Your Honor. A Victorian dresser, oak table, and 2 chairs that were taken.
It was not a furnished apartment.
1 second, let her finish. Go ahead.
Also, it cost me $250 to get it cleaned. She had her boyfriend in there, which was not authorized. Dog's not authorized. She retained the keys for 21 days. I was not able to rent the unit for a month because she held the keys for 21 days, even though she had another place to live by the end of that month. So I have a loss of revenue of $1,350 for lost rent. $980 for missing furniture, $250 for a cleaning fee, of a total of $2,580. And I don't have a receipt in my files that shows that she is entitled to this. Community Housing Network, I believe, is who usually gives that information. Unfortunately, I had hired a company to manage my property, and I'm responsible for her action. But I don't, as far as I can see, have a receipt that verifies that she did pay that.
It was submitted in the trial that we went through with the information packet. All of that was submitted. I think Ms. Jorgensen thinks that we're arguing this case at the moment, and I absolutely did not hold the keys. On the 20th, when we went to court, Your Honor, you ordered me to 48 hours to drop them off. I dropped them off on the 21st of October to your clerk.
With all due respect.
Pardon me?
I believe you said, Ms. Jorgensen, the day after you picked them up, right?
Those keys should have been returned to me by October 1st. And with delays and so on.
Case.
Okay.
So, but here's the deal with in regarding the security deposit. Within 45 days after termination of the occupancy and not thereafter, the landlord may commence an action in a court of competent jurisdiction for a money judgment for damages which he or she has claimed, or in lieu thereof, return the balance of the security deposit held by him or her to the tenant or any amount mutually agreed upon in writing by parties. A landlord should not be entitled to retain any portion of the security deposit for damages claimed unless he or she has first obtained a money judgment for the disputed amount, which you have not done, or filed with the court satisfactory proof of an inability to obtain service on the tenant, or unless, which you haven't done, tenant has failed to provide a forwarding address, the tenant has failed to respond to the notice of damages as required by Section 12, the tenant the parties have agreed in writing to the disposition of the balance of the deposit claimed by the landlord. D, that the amount claimed is entirely based upon accrued and unpaid rent equal to the actual rent for any full rental period or portion thereof during which the tenant has had actual or constructive possession of the premises. So, I mean, you haven't gotten a money judgment. You haven't gotten a money judgment.
And the apartment wasn't listed, never had furniture, Your Honor. It wasn't ever listed as furnished. She's got them listed now. They're not listed as furnished. She's trying to keep this money. And quite frankly, Your Honor, I feel like when I was seeking a judgment from the court, because the judgment from the court is the final word. So Ms. Jorgensen, I guess, feels like she doesn't have to follow a court order.
So yeah, Ms. Jorgensen, you don't have a money judgment, so you're not supposed to hold on to that money. Now you can recruit whatever, but now I want the whole $1,450 here, and then you got to prove, what damages or whatnot occurred into that apartment, because you do have a right to recoup money from the security deposit for damages, but you don't have a right to hold it.
I believe that what she's listing for wanting the keys back October 1st, we were still in the middle of a trial. The trial wasn't finished until October 20th. So the keys were not going to be returned to her October 1st. And she can't go back and charge me for not being able to rent it from October 1st to the 20th. She's the one that filed this case. We were in court because of her.
We can't get the lost rent to that $1,350. The missing furniture, I mean, that could be an option. You gotta prove if it was missing furniture.
Yes, I do, Your Honor.
Is that a small claims court issue?
Hold on one second. And then cleaning and restoration costs, that is something that you can take out. If you have to clean off after somebody, of course you can have that cost recouped out of the security deposit, but the rent and this missing furniture, definitely the rent, no. Cleaning costs, yes. Missing furniture, if you're missing some furniture, then you can take it to small claims court over that, provide your proofs of that, but yeah, that $14.50 needs to be in the court in 2 days. I'm gonna order that in 48 hours.
Okay. And your honor, I do have photos of the unit before and after, and furniture was definitely in there, and she did take it upon herself to take my furniture, the Victorian dresser and the table and chairs.
I got $14.85. I'm trying to figure out where's the $14.85.
That was the
$1,485.
amount that was the original amount that she had me pay her for security deposit was $14.85. I'm not sure how we came up with $14.50.
Okay, $14.85. So $1,485. Let me see. I got that in my notes too. I don't know how we got there.
And again, your honor, my apologies. I had a company that had managed my properties, and I don't have a copy of that receipt. I don't have anything in my bank account that even reflects that amount that was
This
received.
is already a judgment that's been entered, so I'm just asking that the court enforces the ruling.
No, Ms. Jorgensen has to deposit $1,485 to the court. And then, I see the receipt for $200 for cleaning. So obviously, once we sort out, the monies, then we can, return Ms. Jorgensen the cleaning fee, $250, and then the rent fee, we're not getting that back. And then the missing furniture, you can just take her small claims over that. Like, I don't. She's gonna say there's no furniture missing. You're gonna say there's furniture moving. I do see the two pictures. It was an oak table and chairs, and then a dresser with a beveled mirror. Is that the two items?
Yes, and a table and 2 chairs and the dresser. Yes, yes,
Your Honor, she had to move those out when I moved in because I have so much stuff.
That is not true, and you know that, Shelley. I have cameras showing that you took it, so whatever you want to say.
Take me to court, Karen.
All right, so we're all set.
So when can I, Your Honor, what is my move moving forward?
So when so as a matter of fact, in this case, if there's no objection, I can read Ms. Jorgensen, you can take the $250 for the cleaning fee. And then what's the subtraction? 250 from 1,485.
Okay, so that's $1,235, Your Honor.
Yeah, deposit that, and then Ms. Lyons, we need a forwarding address so we can send that to them.
Wonderful.
And Your Honor, could I please have a copy of that receipt that Ms. Lyons has or claims to have for the deposit?
You have all that information in the discovery packets.
I did not receive a discovery packet.
If you got the M-file information, you have it.
Well, with all due respect, if I could ask the courts to please give me another copy, I'd really appreciate that.
We have it, like, we can't produce something we don't have. I look in the online, we don't get discovery here in court, so that's not in our purview. When we try these cases the court does not get discovery.
Okay, well, Your Honor,
if you have it, send it to her.
Yeah, I have no evidence that it was ever paid and who it was paid to.
Your Honor, in the motion that was filed by Lakeshore Legal to dismiss the case, all of the evidence is in there in the motion.
I'm just curious as to who the check was written to. And then I can follow up and see if it was ever deposited or who deposited it.
What check?
One second. So it says to be the community housing network housing program monies due for lease signing. It has her name. This is Jorgensen's, information. It says security deposit 1485. It says please sign and return completed form to Mayor Matthews. So I wonder, does the check go to Tamara Matthews?
There was no, sir. In the security deposit, Karen Jorgensen often works in cash only. So Karen and I took a photo of the cash laid out, and Karen and I both signed a piece of paper sitting at her bar inside of her apartment. And Miss Matthews was there, Karen Jorgensen was there, and I was there. That was all part of the discovery packet. So there are photos. There is a signed receipt by Karen receiving that money.
That came directly from you?
Pardon me?
That cash
Yeah,
came directly from you?
The cash came directly from me. Community housing only paid the first month's rent for me and then continued to pay rent. And then Karen, I was only supposed to be paying $273 a month, but Karen, because I didn't have a caseworker, I think we argued this whole thing in court. Karen convinced me that I was supposed to be paying her $535 a month, which is $300 over what I was supposed. So she took not only the $1,485 from me in cash, but she was taking $300 a month extra in cash from me every month, over and above what the agreed amount for community housing.
I think we're just speaking right now about evidence about whether that deposit or that amount was given for.
And that deposit was given to you. It was given in cash.
I don't have a copy of it. So
when Tamara Matthews gave you a check.
Could you please give me another copy? That's all I'm asking.
Absolutely.
Okay.
Absolutely.
Thank you.
So we're all set. So Miss Jorgensen deposit $1,235 to the court, and then you can keep $250, like I said, for the cleanup costs. And then about the furniture, you can go to small claims court about that.
Okay.
Then,
Your Honor, if there's no evidence to show that she paid it, then I'm kind of perplexed why I'm reimbursing her.
There is evidence that I paid it, Karen. And this is not something, we're not arguing this case. It's already been decided.
Hold on one second. I can give, and so my issue is, how am I running a business, or how I'm being a landlord, how I'm being a corporation, and I don't have receipts, or I'm entering into business without the proper paperwork. I'm sensing a theme here in the city of Pontiac. I'm sensing a theme between business owners that we don't have our paperwork together. Like, I just don't understand. If I can go to General Motors, they have receipts on everything. Everything. That's a multi-billion-dollar, multinational, international corporation that can pull a receipt if I need one.
Your Honor,
but I just don't. But hold on one second. I don't understand how you're entering into landlord-tenant relationships and you don't have a copy of a receipt of the transaction for a security deposit. Like how are we entering into? And I'm not chastising, but you're sitting here asking her for a record that you should have.
You're right, Your Honor. I had a company. You're right, Your Honor.
Well, hold on 1 second, Ms. Lyons, 1 second. I'm not done. But you that's the agency of your business. You got to vet these companies and you got to keep them. You just can't say, go manage my properties and I'm going to go to, Costa Rica and live life. No, you have to have oversight over them as well to make sure that they're keeping your books. So this is your company. And so now, Ms. Lyons, because I don't have discovery. Once again, the court does not get discovery in these cases. So I don't have nothing to offer you. So Ms. Lyons, if you have that receipt, I can give you a week to give it to Mrs. Jorgensen. and we can come back so we can figure out the security deposit.
Thank you.
Believe me, I moved in December of last year. You better believe if I didn't give her a security deposit, she would have hauled me into court way before May for a lot more than $1,500, Your Honor. She would have drugged me into court way before that. So all I'm asking now is that we're not retrying the case, that the court just enforces that Ms. Jorgensen give me. I've been going through this with this woman since May. I had to take her to trial for a fraudulent case that she filed against me. This
So,
is
Ms.
all
Lyons,
been fraudulent.
I
So
understand,
now
Ms. Lyons, do you have a receipt? Do you have a
Pardon me?
receipt of the attorney?
Of
Do you have a
course I
receipt?
have a receipt.
Can you please email it to her?
I will email it to her. I'll email it to her right now. But what
Thank
I'm
you. Do
asking
it.
is that what I'm
Thank-
asking is Miss Jorgensen has willfully exhibited contempt of court by not putting any money in the courts like she was ordered to do. That's contempt of court.
I understand what you're saying. This landlord-tenant relationship is severed. This is one last step. Y'all don't have to speak to each other ever again. So,
I'm just-
can you send?
Why do I have to prove to her that I gave her a security deposit? She knows I gave it to her. I would have, through Community Housing Network, they would have never let me move in anywhere unless I had all my ducks in a row.
Ms. Lyons, I understand. I would like to see it as well. It's not just because of Ms. Jorgensen. Like, I'm passing money along, so I want to be heard. It ain't even about Ms. Jorgensen at this point.
Absolutely.
She's only going to keep $250. She may sue you over the furniture or whatever. That's down the road. I don't care about that now. I want to see the receipt as well, so I'll give you an email to send that receipt to.
Okay.
But I'm still going to order Ms. Jorgensen to put $1,235 into the court within 2 days and go from there.
Okay, and Your Honor, it should be addressed to the 50th District Court?
And what?
What name should be on that check? You just want me to write it out to, Michelle, what name are you legally going by?
I'll put it on the 50th district.
Michelle Lyons, Karen.
50th district. Don't
Thank
put
you.
it there. Deposit
Thank-
to the court.
Okay, thank you, Your Honor.
And we'll send it. Ms. Lyons,
Okay.
do you see that email to send that receipt?
Nope, hold on just a second.
It's in the chat. Write it down.
Oh, I do see it.
So write that down and send that email. Send us receipt to that email.
I sure will.
All right, and then I think you have Ms. Jorgensen, so add Ms. Jorgensen to that email.
Wonderful.
So you're all right.
Thank you, Your Honor. I appreciate your help.
you.
Thank you.
If you're involved in a dispute with another party such as this and you just can't seem to work it out, don't resort to taking the law into your own hands. You take it to court.
All right, thank you very much. Officer Burrell's waiting for you, and that will bring this case to a conclusion.